Please can I ask you to stop any interference on the webinar, please can I ask you to mute your phones. If you have any questions during the webinar, please feel free to post them via the chat option. Jill and Nicola will endeavour to answer as many as possible at the end. And following the webinar, we will email the slides and any supporting documentation to you. This will include a short questionnaire about how you found the webinar, and we would really appreciate any feedback you have to help improve the service to you. Please don't forget that all of these resources can be accessed via the dedicated County FA area of our website, and the link is actually on the slides there. That's all from me. I would now like to hand over to Jill and to Nicola.
Good afternoon and welcome to the webinar. As Andrea said, this is all about data protection. It is intended as an introduction only and focuses on the key issues and the most frequent matters that are raised with us through the FA helpline that we operate. So, who are we? On the slide there you can see my name is Jill Hunter. I head up the commercial team here at Muckle LLP, and I have 18 years experience advising private and public sector organisations on commercial legal matters, including data protection and information security. I have with me Nicola Barnett. Nicola is a solicitor. She specialises in data law, but is also a qualified data protection practitioner. Prior to her legal career, Nicola spent 5 years in-house at a public body as their data protection officer. So Nicola is uniquely placed to advise, having been on both sides of the fence and able to apply the law in a very practical way. So, the aims and objectives, what do we want to get out of today? By the end of this webinar, you should have a general understanding of the data protection regime in the UK. You should have an ability to recognise data protection issues in your organisation, and you should also have the ability to take appropriate action or seek appropriate help. We know that quite often the clubs will come to you for advice on issues like this, and therefore what you also need is an ability to signpost clubs and leagues where appropriate. We're going to cover a number of topics, and they're set out on this slide. We will set the scene by looking at a bit of background to the Act. We'll look at the basic principles that form the backbone of the Act, and we'll focus in on Principle 7, which relates to data security. We'll also discuss data sharing, as we're aware this is common between the FAs, leagues and clubs. We'll also look more closely at subject access requests, as this tends to be one of the most contentious areas and it's something we're approached about very frequently. We'll also examine how social media impacts on privacy and is affected by the data protection legislation. And finally, we'll give you a forewarning and a heads up on some new data protection law which is heading our way. So to put all of this into context, the Data Protection Act governs the collection, use and processing of personal data. It's designed to protect individuals' rights in their own personal data, not organisational data. The Act came in 1998, and since then there have been a number of developments. Technology has obviously developed at a rapid pace, and personal information can be gathered and shared quickly and by innovative means. We now have tablets and smartphones, and some of these things have fingerprint scanners. There are new devices like Google Glasses, where information can be delivered direct to your glasses lens. And the business world has changed dramatically too, and now most organisations embrace home, remote or mobile working to some extent, all of which have data protection implications. Individuals' awareness of their legal rights and potential intrusions into their privacy have also been heightened, and there's now a legal right to privacy continuing to develop by case law. We live in an increasingly consumer-driven environment where we demand information at our fingertips and for everything to be linked together, and as a result, a massive amount of this information is now held in the cloud. Coupled with this, social media has grown, especially over the last 3 years, and this means that personal data is not only being processed, but actively published every second. And this has implications for both employees and employers, which we'll look at later. So, with all of this in mind, how does the Act require organisations to behave when they're handling personal data? Now, before we can look at the specific requirements of the Act, it's important that we understand some of the very specific terminology that the Act uses. We've already said that the Act is about personal data, and that is data that identifies a living individual. So in a club context, that could mean a season ticket holder's name and address, but it might also mean their ticket or membership number, as that too could identify that individual. The Act also identifies a specific category of personal data, which is known as sensitive personal data. And this is data that relates to a specific list of data within the Act, which is race and ethnic origin, political opinions, religious and cultural beliefs, trade union membership, health, sex life, criminal record or criminal proceedings relating to an individual. And if you're processing this type of information, you must make sure that you put in place the extra controls that are required under the Act. The Act talks about data subjects. Data subjects are the individuals about whom personal data relates. We also talk about processing under the Act, and processing can encompass anything that you do with personal data. That can include just simply storing it, accessing it, using it, or transferring it to another organisation. It isn't just restricted to transfers or sales of data. The Act talks about a data controller. Now, a data controller is not an individual. It's not the data protection officer within an organisation. Data controller is the organisation itself that owns, controls and makes decisions about personal data and how it's processed. And the data controller has liability for its personal data. So in your world, the FA, a club or a league, all of these organisations may be data controllers. The Act talks about notification and a requirement for organisations processing personal data to notify the Information Commissioner's Office, or the ICO, of their processing activities. This used to be known as registration, and it's really important that all data controllers who are required to notify do so. If not, it's a criminal offence. There are some limited exemptions from notification, and it may be that even if you complete the online questionnaires at the ICO's website, you may think that you're exempt from notification. But our advice would be to notify even if you believe you are exempt. It only costs £35 a year for most organisations, and the application can be made online. The address is there on the slide, and it's worthwhile doing so just to have the comfort to know that you are not committing a criminal offence by not having the notification in place. And just to be clear, the ICO, the Information Commissioner's Office, is the regulatory body responsible for enforcing the Data Protection Act. It has wide-ranging powers to require organisations to take action, and it can issue fines and penalties, but it is also there to offer advice and assistance, and there's a wealth of guidance to be found on the website. The data protection principles form the backbone of the Data Protection Act, and if you follow them, it should ensure compliance. All are fairly common sense at a high level, but each has a complex body of rules and guidance sitting below it, and some will be more relevant for you than others. The first two, that information must be processed fairly and lawfully, and the processing that you carry out must be for specified and lawful purposes, make it clear that you shouldn't be processing personal data in a way or for purposes that the data subject would not reasonably expect. For example, if you hold employee data, as I'm sure all of you do, then those employees would not expect you to use that data for the purposes of anything other than the employment relationship. You couldn't, for example, without the employee's consent, use that data to send marketing information about clubs to those employees. Principles 3, 4 and 5 sit nicely together. Here, the general message is to keep on top of your data, making sure you've got systems in place to ensure you only hold what's necessary and that the data is accurate and up to date, and that you dispose of it once you no longer need it for the purpose for which it was originally acquired. And if someone does contact you to tell you that their information is inaccurate or out of date, then you must have systems in place to take action to rectify the situation. Principle 6 talks about processing in accordance with the rights of data subjects. We're going to talk about this in more detail later on when we look at subject access requests and the rights of individuals to have access to the data that you hold about them. Principle 7 covers data security, and again we'll look at this in more depth later on. Principle 8 is an interesting one. It restricts transfers of personal data outside the EEA, which is basically the EU and a handful of other countries. It allows transfers in exceptional circumstances, on specific circumstances permitted by the Act. And you might believe that as a county FA, you have a limited need to transfer data abroad, and so that this principle might not apply to you. However, the principle still applies even if the transfer happens incidentally to other activity. A good example of this is where you host IT systems and databases in the cloud or offshore. And often these are hosted outside the EEA, particularly in the US, in which case you'd need to make sure that you complied with the requirements of Principle 8 as well. I'm going to hand over to Nicola now, who's going to take you through Principle 7.
Thanks, Jill. As Jill explained, Principle 7 deals with data security and requires that the county FAs as data controllers ensure the security of any personal data that it processes. The actual wording in the Act is that each data controller takes appropriate technical and organisational measures against unauthorised or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. Obviously the wording's a little dense there, so I'm going to unpick it a little bit. Technical measures relate to those things that we automatically think of when we think of data security, such as firewalls, passwords, antivirus software and things like that. However, the Act also talks about organisational measures that are of equal importance. These types of measures may include implementing policies and procedures, providing training, and physical security such as building access and lockable cabinets. The question of what is appropriate or adequate is much more difficult to answer. The ICO tends to adopt a proportionality-based approach, which means that if your data processing is fairly minimal, they won't expect you to have spent £250,000 on a top-of-the-range IT system. The first step in this is reviewing the data that you process in order to work out what level of security is appropriate. Jill also talked about data processors and what they do, and Principle 7 also governs the way in which a data controller, such as the County FA, interacts with its data processors. A data controller not only has to think about its own compliance with Principle 7, but where it uses a data processor, it's also responsible for ensuring that the data processor complies. When choosing a data processor, a data controller must select one that can guarantee a sufficient security of the data controller's personal data. A data controller should take reasonable steps to ensure that a data processor can do so, and must have in place a written contract with that data processor, setting out the scope of their role and the security standards that they are expected to meet. Serious breaches of Principle 7 must be reported to the ICO as a regulator. I'm not going to go into too much detail on that today, but there is a significant amount of information and guidance available on the ICO website. Jill touched on the power of the ICO to fine organisations, and you may have seen some of these data breaches in the news. For example, Sony's customer database was hacked and they were fined £250,000, which was the largest fine issued at that time. Also, Aberdeen Council were fined £100,000 when one of their employees working at home unknowingly had software on her computer that uploaded sensitive information to the internet. Now, I've specifically mentioned these two because it's important to note that even if as an organisation you haven't actively done something wrong, in your case dropping a membership list in the street for example, you can still fall foul of Principle 7 if you fail to take sufficient steps to prevent a breach from happening. Let's move on to data sharing. I'm going to touch briefly on data sharing, as it's something I'm often asked about. If your organisation is sharing data, and for example, between the county FAs, with the clubs and leagues, or with the FA itself, there are a number of things that you need to think about before you start sharing this data, and these are set out on the slide. The ICO has also produced a fairly user-friendly code of practice on data sharing that is available on their website. The code deals with situations where the sharing of data may be on a one-off basis, for example, the sharing of transferring player information between county FAs, or systematic, ongoing data sharing, and this could be the sharing of membership lists between leagues and county FAs. The sharing of this data in all circumstances must be lawful. One way of ensuring this is to get the consent of the data subject. However, even if the sharing is lawful, the requirements of Principle 7, which as we remember relates to keeping data secure, still apply to both the recipient and the discloser of that data. Wherever possible, data sharing arrangements should be documented in a data sharing agreement. And for you and other data controllers, this means that it is important that you consider these points before sharing any data. Before I hand back to Jill, I'm going to look at subject access requests, as this is the issue that crops up most, not only with other clients, but also on the FA helpline. For anyone who isn't aware, the Data Protection Act grants a right of subject access to data subjects. This means that any individual can write to an organisation and ask for any personal data that is held about it. This may be in the form of a general request for all information, or maybe a request for certain specific documents. Subject access requests are usually quite contentious in nature, as they are often asked in the context of employment grievances or other similar incidents. On receiving a subject access request, the Act obliges you as a data controller to tell the requester whether any personal data about them is held or not. If data is held, the data controller must give a description of that data, the reasons for which it is being processed, and the source of that data. For example, an employer may confirm that it holds data in the form of a medical report which was received from the requester's GP and is held to determine the requester's fitness to work. In addition, subject to a limited number of exemptions, and we'll come on to these in a little while, the data controller must provide the requester with a copy of the information. Once a request is received, the data controller has 40 calendar, not working days, to comply with the request. And a data controller can charge up to a maximum of £10 for processing the request. The data controller is entitled to ask the requester for identification so as to avoid disclosing personal data to the wrong person. As I mentioned, there are a limited number of exemptions that mean you may not have to release certain information in response to a subject access request. However, the majority of exemptions are extremely complex and should be applied with care. I'm going to touch on one or two so that you have an understanding of the types of situation in which they could apply. And the first on the slide there is negotiations with the requester. This would most likely apply in situations where an employee is in the process of negotiating a compromise or settlement agreement with their employer and may submit a subject access request in an attempt to gain a negotiating advantage. In this case, the request could be refused on the basis that there is a substantial chance that the disclosure would harm those negotiations. It's also relevant in the context of insurance claim processes. And the second example on the slide there is management information. And this exemption is most often used where a redundancy process is ongoing and an employee submits a subject access request in order to gain access to information before it is made public to the rest of the workforce. In this case, the request could be refused on the basis that to disclose the information would prejudice the conduct of the business. The third exemption there is legal advice, which should be fairly self-explanatory, but allows requests to be refused where the requested information consists of data to which legal professional privilege may apply. For example, if a club or the county FA seeks legal advice on a change of ownership of a club, where the FA needs to satisfy itself that the prospective new owner satisfies any fit and proper person requirements, any request for that advice could be refused. Finally, one that crops up frequently is third-party data, and I'm just going to use a case study to illustrate this one. So it's not an exemption in itself, but crops up quite often. In this example, a youth match referee is accused of verbally abusing a number of players in a specific match. A number of parent spectators present at the match give witness accounts to the club secretary, and the referee is suspended from his duties as a result. He is naturally aggrieved at this and submits a subject access request for those witness statements on the basis that they contain his personal data. Now, whilst this is true, the witness statements will also contain the personal data of the people who gave them. The access that you do not have to comply with the subject access request if doing so means that a third party can be identified from that information, unless 1. That third party has consented, which in this particular case study seems unlikely, or 2. It is reasonable in all the circumstances to disclose without the consent of that third party. And when considering whether it is reasonable to disclose without consent, the data controller needs to look at a number of factors. Whether the individual in question is owed a duty of confidence. For example, this would often apply in doctor-patient relationships. Whether that individual is capable of giving consent, either from medical reasons or whether they are a child. And 3, have you asked that individual and have they refused consent? The circumstances of each particular case should also be taken into account. Here it's likely that the information should be withheld, provided that consent is not forthcoming, unless the third-party data can be deleted from the statement. This is unlikely in the case of a witness statement, as it is not as simple as deleting a name. Information given in the body of the witness statement, such as where that individual was standing at the time of the incident, could identify that individual. And now I'm going to hand back to Jill to talk a little about social media.
As I'm sure everyone is aware, social media is now externally extremely widespread, and it's now used by many as a method of personal communication in the same way as text and email. But its impact can be much more wide-ranging, and data published through social media can spread like wildfire. Even if you just look at Facebook and Twitter, you can see how prevalent social media is. Facebook now apparently has over 665 million daily active users, and Twitter posts over 400 million tweets a day, and there are over 1 million new accounts opened daily. Because of its power, it can be a useful tool for organisations. It can help you to reach new audiences and customers, helping you to promote what you do to new sectors and markets, but it must be approached with appropriate caution. And there are many, many examples of when social media has been used inappropriately and there have been negative consequences. And you only have to look at recent headlines. Michael Chopra had action taken against him by Blackpool, his club, twice in a week for inappropriate tweets criticising his club. And he was fined £15,000 on one occasion and banned from the first team on the second. This last week, 2 individuals pleaded guilty to sending threatening tweets to the feminist campaigner Caroline Criado Perez. I'm sure you'll have seen that on the news headlines. And one of those individuals is currently held in custody, and that's how serious these things can get. In 2012, Rio Ferdinand was fined £45,000 by the FA for retweeting with LOL or laugh out loud racist comments made about Ashley Cole. Another one that you might not be aware of is a guy called Mark Davidson. Mark, ironically, was a social media consultant who hired a ghostwriter to run his Twitter account. He subsequently fired his ghostwriter, who, in retribution, locked him out of his account and used it to tell his side of the story, which, as you can imagine, wasn't particularly complimentary. And this highlights the importance of putting in place checks and balances when you're hiring someone to manage social media accounts on your behalf. This quite often happens. If you want to get regular feed out to your followers, you get somebody else to write that for you, but you must make sure that you control that properly. Another cautionary tale is that of Nyanza Roberts. She was a primary school teacher in East Hull who took to Facebook to brand her students thick and inbred. She was suspended and she later resigned, alongside the school's head teacher, who also participated in the online conversation. So again, you can see the dangers of using social media without thought. However, the tribunals and the courts are inconsistent, particularly when it comes to disciplining employees for misuse of social media. If you contrast these cases with the Asda case that's up there, in this case an employee posted on Facebook that hitting customers in the head with a pickaxe would make her happy. The employee's dismissal, however, was found to be unfair, and it seems to be that that was primarily because the tribunal said she didn't have enough Facebook friends to have an impact, which seems rather bizarre. But as I say, the courts and the tribunals can come up with unexpected decisions. So the important thing for you is to reduce your risk as far as you can. So what can you do to do that, to reduce the risk of your employees causing you and the clubs damage and or embarrassment? It's key to have clear, proportionate policies in place which set out what is and is not expected when employees use social media, and also to set out what the consequences of misuse might be. Now, I'm sure you've heard this said to you before, you must have a policy in place, you must have a policy in place, and that will sort everything out. But it is not enough simply to have a policy. You must be able to demonstrate that your employees have understood and have the skills to implement the policy. For example, if you expect Facebook privacy settings to be adjusted in a particular way, then you need to tell your employees how, from a technical perspective, they can do this. So you must provide adequate training on all aspects of the policy, including the practical aspects. To avoid the Mark Davison scenario, as I said previously, you need to ensure that those responsible for official feeds, whether they are employees or external agencies or people, are aware of their boundaries, and that they have systems in place that mean that once the role has come to an end, those individuals or agencies cannot technically continue to participate in your official messaging. So, for example, you need to make sure that as a role changes or the responsibility for a feed changes, the passwords that are associated with that social media channel are also changed. It's also very important not only to have your policy and to have trained your employees about it, but for you then to enforce it and to enforce it consistently. If you don't do that, you will run the risk that a tribunal will say it has no effect. Quite often, damaging comments or comments likely to cause reputational damage come from outside an organisation. Fan forums are rife with very strong opinions on all sorts of matters, and it can make it difficult to deal with if the people making the comments are not employees or under your direct control. If comments are made by those who have some connection with either the clubs or the FA, for example, season ticket holders, you can try and impose controls and policies on them at the point when they sign up for membership or apply for a season ticket. Again, those policies must make it clear the consequences of them not being followed. For example, if you wanted to state that a season ticket holder might be forfeited if they've breached the policy, then you need to make sure you do that and they're aware of that at the point when they apply for the ticket or for membership. If the comments are made by third parties with no connection to the clubs or the FA, then it can be much more difficult to prevent the publication in the first place or to stop the spread of damaging material. You need to work out whether the comments that have been posted are just irritating or whether they actually have some legal grounds for recourse behind them. And that might be because they're defamatory or threatening or discriminatory in some way, or give rise to some other sort of legal right against the person making the comments. And then you may be able to take action. In many cases, it can be very difficult to work out the identity of the person posting the comments. Most don't use their real names when they're being abusive. You may need the cooperation of the media channel owner or the ISP, or to involve the police, or even to obtain a court order in order to get access to the identity information before you are even in a position to start to take legal action. Organisations such as Twitter and Facebook will usually cooperate in removing illegal posts, but can be very protective of the identity of their users. This is illustrated in July last year. France's Union of Jewish Students took legal action against Twitter after it refused to reveal the identity of the author of some anti-Semitic and racist posts. There was a very, very lengthy legal battle that went to appeal. It did eventually settle, and the data was released, but it took a long time to achieve that result. I'm going to hand over to Nicola now, who's going to talk about the new law that's on its way and how that might affect what we've been talking about so far.
Thanks, Jill. As Jill's mentioned, we've talked a lot about current law today, and hopefully some of you are still awake. And now I'm going to very briefly cover some future legislation that's going to change data protection across Europe. As some of you may know, there's a new European regulation incoming that will replace the Data Protection Act as we know it. Unlike the Act, which is a UK-only domestic legislation, the regulation is directly applicable across Europe, which means that UK implementing legislation is not needed. This is intended to ensure that all EU countries are consistent in their approach to data protection, which is certainly not currently the case. The text of the regulation is currently being hotly debated in Europe, and once it is agreed, we'll have a grace period of 24 months to comply before it is fully in force. Now, as the text is yet to be finalised, the points on the slide there are subject to significant change, but it is likely that the most relevant points in the new legislation will be. The first major change is fines. Jill mentioned earlier in the webinar that the ICO has an ability to impose fines on organisations in breach of the Data Protection Act. Now, this is currently limited to a maximum fine of £500,000. Under the new regulation, the maximum fine will be €100 million, or 5% of global annual turnover, whichever is the greater. Obviously, this is a huge increase. It's also likely that the requirement to notify that Jill talked about earlier and maintain a registration with the ICO will disappear, although organisations will be required to maintain this information internally within the organisation instead. This amendment has been heavily resisted by the UK government, as it believes strongly that this will cause a massive burden on organisations in terms of internal bureaucracy. However, we're yet to see whether that will remain in the current text. The ability to charge £10 for subject access requests is also likely to go, and the appointment of data protection officers will be mandatory for organisations that process large amounts of personal data or that process certain categories of sensitive data. These data protection officer posts will be protected from termination for either 2 or 4 years, depending upon whether it is contracted out to an external professional, for example a solicitor, or filled by an employee. And finally, organisations will be able to certify their compliance with the regulation under a process that is to be agreed, and in return will receive a seal of compliance. The regulation will also apply to non-EU organisations that process the data of EU subjects, and this is designed to capture organisations such as Facebook that are currently notoriously lax on data protection.
So, after you've attended an update or a briefing session like this, I always think it's a good time to take a look at your own organisation, review your own practices and take action. I think the key actions coming out of what we've talked about today are for you to undertake a review of your own personal data held within your organisation. Understand what it is, where it is, and what you do with it. That sounds fairly straightforward, but it can take some time. But you need to be looking at key areas of the business, such as marketing, HR, where you tend to hold the bulk of the information. But you might find that you hold some unexpected pieces of personal data elsewhere in the business, which doesn't receive the normal level of attention in terms of data protection regulation. As Nicola's talked about there, you should check your organisation is notified and that your notification covers all of the processing that you do. Each separate legal entity in a group of companies must be notified. So, for example, if you have a holding company with 2 subsidiaries, the subsidiary companies cannot rely on the holding company's notification. Each of them must hold its own. It's not mandatory yet, but it is a good idea to appoint and train a data protection officer who can take control and responsibility for compliance within the organisation. You do need to make sure that you have clear policies, including social media policies, within your organisation, and we can help you prepare these if necessary. And you need to provide, as I talked about earlier, adequate training on those policies to the people you are expecting to comply with them. If you engage in data sharing, You need to check that there's appropriate data sharing agreements in place with the people with whom you're sharing the data, and if there's not, you need to get them in place. And you need to check whether you have third parties carrying out data processing on your behalf, and you need to make sure that the appropriate data processing contracts are in place that Nicola talked about. It's also a good time just to generally revisit your data that you hold, to cleanse it, update it, and make sure it's accurate, up to date, and relevant. And if you take one thing away from this today, let it be this: data protection is just that. It's protection. Despite what a lot of people think, it's not data restriction or data prevention, and it doesn't have to be a barrier to business. It can be an opportunity to improve your data security and also to improve relations with the people whose data you hold. And this is the approach that's being taken in the regulation that Nicola's talked about. The landscape is changing to fit, and risk management is the key, but data protection isn't something to be frightened of. If you're informed and sensible and you take appropriate action and legal advice where you need it, you will be able to manage the data protection issues. If you do have issues that you require support on, then a wealth of information, as I said earlier, can be found on the ICO website. We've put up the address there for you again. And you also, each of the county FAs has access to our county FA helpline, which is open from 8:30 to 5:30, Monday to Friday. Each county FA is entitled to 7 hours free of charge legal advice based on a maximum number of 7 separate inquiries each year, with 60 minutes for each inquiry, either by telephone, email, or written. And if you need further support, which would involve paid work, then obviously we will agree fee structures and estimates prior to engagement. And we've already negotiated competitive discounted rates with the FA, and we give 10% of our ongoing fees back to the County FA helpline to help provide future support. As Andy said right at the start, there's also a dedicated County FA area on our website. We'll post the webinar recording and any supporting materials there so you can revisit it at your leisure. And post-webinar, we'll email out to all delegates links to the recording, the slides, and answers to any questions we don't get time to deal with today. And this will also include the brief questionnaire that Andy talked about, and we would be really grateful if you would give us our feedback so we can improve on future webinars. We have had some questions through during the course of the webinar, which we're going to run through now. The first one was a question. Somebody's asked for a little bit of clarification around the difference between a data processor and a data controller. This is something that we mentioned right at the start, but it's come up all the way through. So it's a good question. Data controller, as I said right at the start, is the person who, the organisation who owns, controls and makes decisions about the data and has liability for it. A data processor is a third party who the data controller asks to do something with that data, to process it on its behalf. But the data processor does not have any liability for that data as long as it acts in accordance with the data controller's instructions. So if you appoint, in an FA context, if you appointed somebody to process your payroll for you, an external accountancy agency perhaps will process your payroll for you, you would retain responsibility and liability for that data unless the data processor, the payroll processor, went off and did something with it that you hadn't instructed them to do. For example, if they sold it to a marketing company, then you wouldn't have liability for that. But, as Nicola said, you must make sure you have a written contract with your data processor so that you can make it clear what you are or are not asking them to do with the data. We have another question that has come through that we've been asked to deal with today. And it's quite a tricky one. It's about subject access requests, Nicola, so I'm going to pass this one to you. Subject access request is received for a copy of a letter whom an individual believes may be about him or her, and either names him or her or makes a reference which is in relation to them. In actual fact, within the letter, they are not referred to or named. And so how would the body receiving the subject access request respond? And would the person who was asking for that information have any further legal recourse if they didn't believe the response?
Okay, that's a very good question and happens probably more often than you'd think. on a very basic level, if the letter doesn't mention or refer to that individual and isn't about them and they can't be identified from its contents, then that letter won't constitute their personal data, and therefore it's outside the scope of the subject access request. And the body is perfectly entitled to confirm this to the individual and should do so within the 40 days. So it's perfectly acceptable in those circumstances to respond to the individual confirming that that information is not held. In answer to the second part of the question, if the individual is not satisfied with the response or they don't believe it, which often happens, they can request that an internal independent review is carried out, and this should be carried out by somebody other than the person who responded to the original subject access request. And if the individual is still not satisfied once that outcome has been communicated to them, which again often happens, they can then complain to the Information Commissioner's Office.
Thanks, Nicola. We've got another question here, which is around obligation to provide the police with details. So we've got an FA who has been asked by the police to provide details of a player who plays for a specific team. They have got those details on their database but are worried about whether they should provide them. Do they have to provide the details to the police?
Okay, that's another excellent question and does crop up quite a lot. Despite what people think, the police don't have an automatic right of access to personal data under the legislation, and the FA in that circumstance would have no obligation to provide the information to the police. However, we're just going to come and look on, practically speaking, they may take a different approach. Providing the information voluntarily won't be a breach of the Data Protection Act, provided that the criteria in Section 29 of the Act are met. And that means, provided that the disclosure is for the purposes of preventing or detecting crime or the apprehension or prosecution of offenders, and that not disclosing the information would prejudice these purposes, then that disclosure would not breach the Act.
I don't know whether they know in this circumstance the reason why the police want the information.
No, and that's a good point. Probably in order to have a paper trail and to make sure that the whole process is set down and recorded, I would probably recommend that the FA in that circumstance asks that the request is made in writing, signed by a senior police officer, and also asks them to specify the reason for the request in that written request, and confirm also that in the police's opinion, failing to disclose that information would prejudice their investigation, and then the FA will be covered on all fronts.
We've got, I think, time for another question. How long would you hold ex-employee details? Oh, this is a really good question, and this is something we're asked about a lot.
It is. It's data retention and destruction is linked to the Data Protection Act. Unfortunately, and the question we get asked a lot is, it relates to time periods and how long you should be keeping various categories of data from, whether it be ex-employees or current employees or clients in our case. And the answer is quite unhelpfully that the Data Protection Act doesn't state specific time periods. However, what they normally advise that you take a business-based risk approach, and you shouldn't keep information longer than you need it. So in terms of ex-employees, if there is a business reason that you need to retain that for 6 months or a year or however long, then as long as you have a process for destruction and a reasoning behind that, and you can explain to the ICO or whoever, if questioned, why you kept it for that long, then that's fine.
So that's quite good in a way, that there isn't a specific, it's up to you to decide what's appropriate for your organisation.
It is. I mean, there's some non-statutory basis for this. For example, I think it's CIPD, the HR regulatory body, sets out some recommended retention time limits for personal data. So if it's HR related, it's always good to have a look there. And historically, I think some people have kept ex-employee details for 75 years until pensionable age, and usually the reason for keeping data relates to pension payments. So if you have outstanding pension obligations, then you may need to retain that data for longer than others do.
But you may be able to actually retain only parts of that data that are relevant. So I can think we hold all sorts of data about our employees, like emergency contacts, all of that sort of stuff, which quite often will involve third-party data as well. But if you're keeping information because for pension purposes, you could get rid of a lot of the information that you don't need for that purpose and just keep what's absolutely relevant, and that would help you to comply as well.
Absolutely.
Okay. We've had one more question which I'm not quite sure about what we're aiming at. So we'll try and answer it, but if it's not what you were wanting us to answer, then let us know. You've asked how you determine what threshold a county FA achieves with regards to the extent of its data processing. I'm not quite sure what you mean by that. I think you're saying how do you know whether or not you've complied with your obligations if you are data processing or not. And I think the only way to do that is to look back at the agreement, the data processing agreement, to see whether you have complied with those requirements within the contract. But outside of that, I'm sorry, I'm not quite clear on your question. So if you want to email it through to us, we're happy to look at that separately. If you want to email it through to the County FA helpline, we can look at that one for you. Or you can give us a call through the helpline. The other question that we've had is about when the presentation will be available to be viewed. It will be available within 24 hours, so probably by close of play tomorrow. And it's fine for it to be shared with board members, senior staff within the organisation. Obviously, the more people that know about data protection within the organisation, the more chance you've got of complying and not falling foul of the law. I think we've got time for this last question that's just come through. We have players registered with the county due to registration scheme, and also these players appear within the affiliated league's data. So who is liable for breach if data is passed on? Because the person in this case is worried whether or not the FA is protected if the other party who also holds the data causes the breach.
That's a really interesting question, because we've taken quite a lot of time to explain the difference between data controllers and data processors, but it's also possible for two organisations to both be data controllers in relation to certain data. So, for example, from our point of view as a law firm, we may hold personal data about some clients that, due to the client's affiliation with a different law firm, the other law firm also holds. Now, if that other law firm breaches their obligations under the Data Protection Act, even though it relates to the same information that we have, we won't be liable, because in those circumstances, each of us is a data controller, and each of us will be responsible for our own compliance and liable for any breaches that occur as a result. So the mere fact of you happening to hold the same information as another data controller, such as a league, doesn't mean that you'll be liable for what they do with it. They wouldn't be a data processor in that circumstance. They would be a data controller who is liable in their own right.
I think the only scenario where you might be would be if you were joint data controllers of the same information, but that sort of scenario usually arises where you undertake some sort of joint data collection activity. Typically, it happens in marketing scenarios where you're collecting information for marketing lists to do a joint event, perhaps with somebody else. The data, the final list that you put together of personal details, you could be joint data controllers in respect of that information, and you would have joint liability. I think that's all we've got time for this afternoon. As I said, there's lots of questions coming through there, and we appreciate that it's a complex area and one where people can feel pretty much alone. So if people do have queries that they want to pick up, please do use the helpline, either through email or through the telephone, and do check out the ICO's website, because there's a lot of information on there. And we'll get this webinar and the supporting materials up on the website tomorrow. Thanks very much.
Thank you.